Thank you for joining me. My name is Marc Fitapelli, and I'm an attorney who represents investors nationwide in FINRA arbitration cases against broker-dealers, financial advisors, and other individuals who sell securities. I'm here today to talk with investors about the options that you may have to pursue individual FINRA arbitration cases against the salesperson who marketed GWG L Bonds either to you or to someone you know. Before I get into the substance of my presentation, I just wanted to put up a couple of very quick and brief disclaimers, and I'm not going to read them all, I just wanted to highlight two of them. So first, while this presentation is educational in nature, I want everyone to understand that this is attorney advertising, and the purpose of the presentation is to convince you to eventually hire our law firm. We hope that you would retain us to pursue your claim involving GWG. Second, what we're discussing here today involves allegations. There's been no finding of liability by the government against GWG. So while these are very serious allegations, there's been no finding of fault. So with that in mind, what I'd like to do first is I'd like to just discuss with you what GWG does as a company. Then I'll get into the L Bond program, the current problems with it, and finally, I'll conclude with the options investors have to pursue individual FINRA cases. So first, what is GWG and what does it do as a company? Well, GWG is a publicly traded company. It's a Texas-based company, and its core business operation involves purchasing life insurance policies from individuals who either can no longer afford the policies or simply no longer want to afford the policies. So what GWG does is they'll approach these people, they'll pay them cash to buy the policy, and then they'll continue making the premium payments to the insurance company until the person eventually passes away. And the way that GWG earns a profit is by eventually realizing the death benefit when the person passes. They have other lines of business. They're similarly complex, where GWG is providing what it calls liquidity needs to people who own otherwise illiquid investments, things that are similar to life insurance policies, but a little bit more complicated. Because this is their core business operation and because it naturally involves a lot of cash, GWG came up with a program that it called its L Bond program. And I'll put up for you on the screen the schedule of payments for L Bonds, but the idea was that these investments were going to be marketed to retail investors, mom and pop investors, and they would be marketed on the radio, through newspaper advertisements, through free steak dinners, basically through the conventional means that everyday Main Street retail brokers have to reach out to clients. The investments weren't sold to large institutions, and they weren't sold to hedge funds. They were sold to everyday investors. And this is what people were promised. They were promised that they would receive this income based on this schedule. So if you invested for 6 months, you received 4.25%, and if you invested longer, you received a higher interest rate. The actual interest rate that you may have received on your L bond may be different from this schedule. This schedule is based on a prospectus that was filed with the Securities and Exchange Commission in 2020. We have clients who I think have different maturity schedules. The next slide I'm going to put up for you is going to talk about some of the fine print. So that was the pitch, right? But what was the fine print? And what were investors taking on in exchange for what they thought was a guaranteed monthly payment? And the fine print is important here for two reasons. Number one, your financial advisor is responsible for the fine print. They're responsible for understanding it, and number two, they're responsible for communicating it to you in a way that you understand. So the next slide I'm going to put up for you are the plain words of the prospectus. And you can see here in plain English what GWG told its investors and told the general public, including the financial advisors who sold it, about the product. Investing in our L bonds may be considered speculative and involves a high degree of risk, including the risk of losing your entire investment. And now, you may be saying to yourself, sure, every investment probably has the same boilerplate risk that investors could lose everything. And to a certain extent, you may be cynical, but you may also be correct in saying that. So we need to dig a little bit deeper to see why exactly it says this is a high-risk investment and why exactly it says investors could lose their principal. And the next slide that I'm going to put up for you are some of the basic risks that are contained in the offering materials for GWG. So number one, L bonds aren't credit rated by any agency. So when investors purchase bonds, they may be used to hearing terms like AAA, AA, Moody's, S&P. Those are credit rating agencies that rate instruments like bonds, and they give them ratings. GWG L Bonds didn't have that, and that's unusual for these types of instruments. It's especially unusual given the amount of money that GWG raised. Secondly, GWG weren't insured by any third-party insurance company in the same manner that other bonds are insured. And that's something that was entirely unique to GWG. And it's not something that you would encounter when you purchase municipal bonds, for example. The other risks that we have here on this slide talk about the capital structure of GWG. And what this means here, that GWG L bond holders are structurally junior to GWG's other creditors, and that GWG's prospectus allowed it to borrow up to 90% of its assets. What these other things here mean essentially is that GWG wasn't worth the paper it was printed on. The company was heavily indebted. It had other creditors who had rights to its collateral, who had rights to its assets, and that's highly problematic, and it's going to be both unfortunate and interesting to see how it plays out in bankruptcy court if GWG eventually files for bankruptcy, because the bondholders, at least according to the prospectus, is subordinate to a great deal of debt, and all the company's assets appear to be pledged to someone else. When you look at that, the unfortunate conclusion and the sad reality is that GWG bondholders may recover nothing in the event of a bankruptcy. And that's the unfortunate reality here. So I want to go through with you now the current status of GWG Holdings. So first, GWG Holdings has been under government investigation since at least October 6, 2020. And we know that based on disclosures that they made with the Securities and Exchange Commission. You should write that date down, and you should go and look and see when you purchased your L bond. If you purchase your L bond after that date, you should ask your financial advisor if they knew about this investigation, or if their brokerage firm received the subpoena from the Securities and Exchange Commission and when that subpoena was received. Second, GWG's auditors resigned in December 2021, and GWG has failed to make any recent filings with the Securities and Exchange Commission, including filings regarding their financials. Again, you should ask your financial advisor what the current status is of GWG's financials, and if you could rely on the previous financial information that they've released. GWG has made $0 in payments to L bond holders in 2022. We're filming this video April 13th, 2022, and as of this date, GWG has made zero payments, and it's widely believed that GWG Holdings will file for bankruptcy protection almost any day now, as reported in the Wall Street Journal. It's likely that by the time we put this video on the internet, GWG will have already filed for bankruptcy. Now, why was your financial advisor responsible for this? So there are three core responsibilities that financial advisors have when they sell investments like this. And I put up a slide for you that has all three of them. So first, they're required to understand the complex risks of the investments that they're recommending to customers. So the previous slide that I put out for you that discussed things like the capital structure, how much debt GWG had, the fact that GWG could borrow up to 90% of its assets from other lenders. Your financial advisor needed to understand that, and needed to understand that when you read those things and read those things in concert with the fact that this investment says that investors could lose everything, that the situation that we're in today was entirely foreseeable, right? And that this investment based on all of those things and based on all of those disclosures, shouldn't have been recommended to anyone because of all of those things in the prospectus. And in fact, this investment was recommended by an incredibly small minority of brokerage firms and financial advisors in the United States. The vast, vast majority, 99% of brokerage firms in the United States, did not approve this investment for sale. It was sold by less than 1% of brokerage firms throughout the United States, and it's not surprising. Second, your financial advisor needed to accurately and truthfully disclose the risks of this offering to you. Something that's very important, under the Securities and Exchange Commission rules, omitting something that's very important is just the same as lying. So you have to ask yourself, did your financial advisor lie to you, or did they omit things? Did they not tell you the truth, or did they forget to tell you things that were important? Finally, financial advisors need to recommend investments that are suitable for clients in light of their financial goals. This is an individual standard. It depends on who you are as an investor. If you remember in the beginning of my presentation, I said many of the investors in GWG L Bonds were retail investors, and that's true. Many of our clients are elderly. They invested in their IRA accounts, and many of them lost significant portions of their net worth. And for these people, this third part of this analysis comes into play. And it's especially egregious that GWG L bonds were sold to people in this situation. What's the case against your financial advisor look like? And what are some common concerns and common questions that investors may have? So first, what can you sue for? You can sue for your principal, you can sue for your interest, and you can sue for your attorney's fees. The cases are individual cases. They're not class actions. They're individual cases filed before a forum called FINRA, the Financial Industry Regulatory Authority. Most of the cases settle based on statistics from FINRA, and the average case lasts about a year to a year and a half. The case is filed against the FINRA member firm that held the salesperson's license. This is important. When many people call our office, they think that the cases are going to be filed against the individual salesperson that sold the product. Many people think that it's not worth pursuing these cases because their perception is that this is a small company or a small person, perhaps in a small 1 or 2 person office. Don't think that, please. Call us, and when you look the person up and you look their license up, often the license is held by a large national company that may have liability insurance or may just be very well capitalized and could pay the claim. So don't be under the mistaken belief that the claim is going to be filed against your salesperson or against the company that you were dealing with. It's entirely possible that your claim may be filed against a broker-dealer that was paid a commission on your sale, but whose name may not be immediately familiar to you. So please keep that in mind when you're going through your records and you're deciding whether or not to contact an attorney. Finally, liability for these cases arises under the Securities and Exchange Commission's rules and the rules of the Financial Industry Regulatory Authority. And this practice is an incredibly niche practice. And that brings us to our last slide, and that's hiring our law firm and why I think we're the right law firm to help you to pursue your losses. So I've been doing this for 15 years. I've helped investors recover hundreds of millions of dollars in hundreds of individual FINRA arbitration cases. I've tried many cases to final award. My clients have been awarded full damages. They've been awarded punitive damages. They've been awarded their attorney's fees. I've gotten individual arbitration awards in excess of $1 million. We work on contingency. So what that means is our law firm doesn't earn a penny unless we successfully recover money on your behalf. What I'm currently doing right now is I'm representing many investors who've lost money in GWG L bonds. What we're offering is free Zoom or telephone consultations nationwide. If you're interested, please contact me. You can call using the phone number below, or if you've actually sat through this entire presentation, you can call me at my direct phone number. It's 212-658-1501.